So, we have some absolutely explosive news that just broke on the nationwide effort to eliminate suppressors and short-barreled rifles from federal control completely. 15 states just joined forces in an unprecedented legal attack to end all remaining NFA restrictions. And they're pushing to make it happen immediately. Not next year, not next month, but right now. Make sure you're subscribed to this channel, because the developments coming in the next few weeks are going to be massive, and you don't want to miss a single update. So let's get into what makes this the most significant Second Amendment battle of the decade. $0 tax reality. Right now, under current federal law as of January 1st this year, the NFA tax stamp for suppressors and short-barreled rifles costs exactly $0. That's not a discount. That's not a temporary promotion. The tax went from $200 down to nothing as part of the massive spending bill that passed through Congress. Now here's what most people are celebrating: free tax stamps, no more paying the government for permission to exercise your rights. But there's a problem that almost nobody is talking about. Even though the tax is zero, you still have to register your suppressor or SBR with the federal government. And here's the kicker. Even though you're paying $0, the federal government still maintains a complete registry of every single person who owns these items, where they live, and exactly what they own. And that brings us to why this legal challenge is targeting something far more important than just the money. Constitutional foundation collapses. The National Firearms Act was passed in 1934. And here's something most gun owners don't know. It was never actually justified as a gun control law. The Supreme Court upheld the NFA specifically and exclusively as a valid exercise of Congress's taxing power under Article 1 of the Constitution. The government's entire legal argument was this: we're not banning these items, we're just taxing them. The $200 tax back in 1934 was equivalent to about $4,500 today when you adjust for inflation. It was designed to be prohibitively expensive, but legally it was still just a tax. Fast forward 90 years, and Congress just removed that tax completely. If the NFA is no longer operating as a tax law, then what constitutional authority does Congress have to enforce it? And that answer is connected to what 15 states are about to force the courts to decide. 15 state power coalition: Texas, Alaska, Georgia, Idaho, Indiana, Kansas, Louisiana, Montana, North Dakota, Oklahoma, South Carolina, South Dakota, Utah, West Virginia, and Wyoming. These 15 states didn't just file friend of the court briefs or issue statements of support. They joined as named plaintiffs in this lawsuit, which means they're putting their full legal resources and state attorneys general directly into this fight. To understand how unprecedented this is, consider that most major Second Amendment cases have maybe 1 or 2 states joining in support. But 15 states as actual plaintiffs in a direct challenge to federal law? That's the kind of coalition you see in cases challenging Obamacare or major environmental regulations. These 15 states represent over 60 million Americans and account for approximately 18% of the entire U.S. population. And that political pressure is about to collide with something the Democrats are planning that's even more extreme. Democrats' extreme counterattack. Senator Chris Murphy from Connecticut introduced an amendment that would raise the NFA tax from the current $200, which is now zero, all the way up to $4,479 per tax stamp. That specific number isn't random. It's calculated to be the inflation-adjusted equivalent of what the original 1934 tax would be worth today. But here's what makes this particularly insidious. This isn't just about suppressors and SBRs. The amendment would apply to all NFA items, including short-barreled shotguns, any other weapons, and destructive devices. If you wanted to build a legal SBR and put a suppressor on it, you'd be looking at nearly $9,000 just in federal taxes. And the timing of this amendment is deliberate. It's attached to a must-pass military spending bill. But there's a parallel effort happening that involves a timeline moving faster than anyone anticipated. Summary judgment speed strategy. Both sides in this lawsuit just agreed to skip the normal trial process entirely and go straight to summary judgment motions. For those who don't follow legal procedures closely, that's extraordinary. Summary judgment means both sides are essentially saying the facts aren't in dispute. This is purely a legal question that a judge can decide right now without hearing witnesses or examining evidence for months. The plaintiffs filed their motion on October 7th. The ATF has until November 6th to respond with their opposition and their own motion. That means within 30 days, we're going to see the federal government's complete legal position on whether the NFA can survive without a tax. Compare that to most federal cases, which take 2 to 3 years just to get through the initial phases. This case could have a district court ruling before the end of the year. Federal Registry elimination threat. If this lawsuit wins, it doesn't just mean you don't have to pay a tax or wait for approval. It means the federal government would be legally prohibited from maintaining any registry of suppressors and SBRs. That registry currently contains detailed information on millions of gun owners, names, addresses, photographs, fingerprints, and exact descriptions of the items they own. The ATF knows where you live, what you own, and when you bought it. Now imagine if tomorrow that entire database became unconstitutional and had to be destroyed. That's not hypothetical. That's exactly what the plaintiffs are asking for. But here's the broader implication. If the courts rule that Congress can't maintain a registry under the taxing power, that precedent would apply to any future attempt at universal background check systems or gun registration schemes. Trump ATF's mixed signals. The Trump administration created a Second Amendment task force and installed new leadership at the ATF, who are supposedly pro-gun. But when you look at their actual legal positions in court cases, the picture gets complicated fast. In the Fifth Circuit suppressor case called Patterson, the Trump DOJ filed a brief admitting that suppressors are constitutionally protected arms under the Second Amendment. That sounds great until you read the next sentence, where they argue the NFA restrictions are still constitutional because they operate as a shall issue permitting system. Think about what that means. They're saying yes, suppressors are protected by the Constitution, but the government can still require you to register them in a federal database and get permission before exercising that right. The Bruin Supreme Court decision specifically rejected that kind of permitting scheme for carrying handguns. So, when the ATF files their response by November 6th, their answer will tell us whether the Trump administration is actually willing to dismantle gun control infrastructure. Congressional legislative alternative. While this lawsuit is moving through the courts, Representative Andrew Clyde from Georgia introduced legislation that would completely remove suppressors and SBRs from the NFA through an act of Congress. This is the legislative approach rather than the court approach, and it's significant because it shows there are multiple paths to the same goal. Clyde's bill would simply strike suppressors and short-barreled rifles from the definition of NFA firearms in the United States Code. Done. No more tax, no more registration, no more waiting, no more paperwork. The challenge is that this bill needs to get through committee, get a floor vote in the House, pass the Senate, and get signed by the President. But here's why it matters. If the lawsuit wins in district court and the government appeals, Congress could pass Clyde's bill while the case is still pending. What we're watching right now is 3 separate paths to the same destination, all moving forward simultaneously. So that's the complete breakdown of where we stand right now in the fight to eliminate NFA restrictions on suppressors and short-barreled rifles. 15 states are pushing harder than ever before. The courts are moving at unprecedented speed. And we could see a final decision within months that changes everything for millions of gun owners. If you want to stay ahead of every single development as this unfolds, hit that subscribe button right now, because I'll be breaking down the ATF's response the moment it drops on November 6th, and you need to see what position they actually take. Drop a comment below and let me know if your state is one of the 15 fighting for your rights, or if you're stuck in a state that's doing nothing. This is the most critical Second Amendment battle happening right now, and the next 6 months will determine whether we finally win back freedoms that were stolen 90 years ago. Don't miss a single update.